Next in our guest takeover, we'll explore what happens when divorced spouses need to sell a property they own together. Let's take a look at this scenario. Following their separation and divorce, Dami and Busola are required to sell their jointly owned home. As a real estate lawyer, what legal and procedural considerations arise when selling a property owned by divorced spouses? And how should the sale of the property be properly managed to protect both parties' interests? To help us understand how this process works in practice, including the role of the separation agreement, consent requirements, and the handling of sale proceeds, I'm joined today by Titi from Platinum Law Firm. Titi will walk us through what selling a matrimonial home looks like when parties are going through a divorce. Over to you, Titi.
So when divorced spouses have to sell their home in Ontario, the first thing to consider and to understand is that divorce itself does not change ownership. So if both names are on title, spouses have to both agree to sell and how to sell. If there's any conflict or there's any disagreement in terms of whether or not they want to sell, then the court can step in under the Partitions Act to determine the sale of the property. The next thing to look at is whether or not there's a separation order or a court order. Very often the document tells us how the home must be sold and how the proceeds are to be settled. So the real estate transaction essentially has to follow the court or the separation order. Also, another important issue is to have independent legal advice. Both spouses must have lawyers who represent their interest, and each must align themselves to the terms of the settlement order or the court order, as the case may be. From the real estate side, we also have to deal with title or mortgage issues, such as confirming that both parties are on title, arranging how to make the payout and the discharge, and ensure that neither spouse feels left out or has any other liability arising from the joint ownership of the property. In terms of the actual sale itself, the process has to be structured and transparent. For instance, this means agreeing on who the listing agents would be, how to settle outstanding liabilities that accrue to both parties. In terms of the actual sale, the process has to be transparent and structured. For example, agreeing on who the listing agents would be and how liabilities would be settled. Also, where emotions are high, parties can have a settlement protocol that relates to the sale itself. Finally, the money is handed neutrally. After the sale of proceeds stays in trust, both parties have to be handed their funds neutrally and as per the agreed terms, either in the court order or the separation order. So I believe that this would help parties who go through divorce to know how to navigate the real estate part of the entire transaction and how to get a fair deal for both parties.